New Mexico Real Estate Basics, page 40, is met. The buyer may likewise be liable for failure to perform if the demand is not within the scope of the appropriate law governing the circumstances. Real estate brokers should strongly urge their buyer clients to consult with an attorney before making such demands. If, however, a buyer and seller freely negotiate the withholding of funds for repairs that are acknowledged by the sellers to require completion, real estate broker can assist in the negotiation and request that an appropriate party hold an escrow. The wisest choice as an escrow agent is usually a title company that is familiar with these arrangements. Who keeps copies of all of these documents and for how long? At closing, the broker is required to keep copies of all executed documents for 6 years. The seller's closing statement shows all of the receipts and disbursements handled by the broker. The buyer's closing statement shows all monies received by the broker and how and for what they were dispersed. Can brokers charge to prepare some documents? According to the previously mentioned statement of principles, real estate brokers cannot charge a fee for the preparation of purchase agreements and other documents related to closings. Stigmatized properties. What is a stigmatized property? A stigmatized property is one that has acquired an undesirable reputation. Stigmatized properties can include homes psychologically impacted by newsworthy incidents such as a murder or murder/suicide. Properties suspected of being a front for illegal drug sales, or properties that were the site of a forcible felony. The New Mexico Real Estate Disclosure Act specifically addresses property that is the site of a natural death or the site of a homicide, suicide, assault, sexual assault, or any other crime punishable as a felony. Although such property may be stigmatized, there is no obligation on the part of the real estate broker to discover or disclose these facts. Under the federal fair housing laws, it is specifically illegal to disclose that a property is or has been owned and occupied by a person who is HIV positive or has AIDS. This includes any other disease that has been determined by medical evidence to be highly unlikely to be transmitted to others through the occupancy of improvements to real property. Is there any responsibility for failure to disclose information about stigmatized property? The essence of the issue is discovery, not disclosure. There is no duty for the seller or broker to disclose such information. Based on New Mexico statute, no cause of action is warranted against a broker for failure to discover that the purchased property was psychologically impacted. However, If the broker had prior knowledge, then under an agency relationship, the buyer's agent may have a duty to disclose the known information. Number 41, or page 41. Brokers must distinguish between a stigma and a potential adverse material fact. A drug lab is something that might create an adverse material fact as an environmental cleanup issue. The environmental hazard has nothing to do with the stigma and would require disclosure. Environmental concerns. Who implements CERCLA in New Mexico? The New Mexico Environment Department, NMED, is the enforcement agency for the Comprehensive Environmental Response, Compensation, and Liability Acts, CERCLA, Superfund, and uncontrolled site regulations in New Mexico. This agency may be reached at 1190 St. Francis Drive, Suite N4050, Santa Fe, New Mexico 87505. www.nmenv.state.nm.us. Who is responsible for cleaning up hazardous waste on a property? Responsibility varies because cleanups can be quite costly. Prospective buyers should certainly obtain as many reports as are available from the Environmental Protection Agency, EPA, NMED, and even private environmental specialists. What state agency controls right to water in New Mexico? The New Mexico State Engineer and local conservancy districts control use and distribution of water. Water is scarce and valuable. Often, irrigation and other water rights are as valuable as or more valuable than the actual land to which they are attached. Within limits, water rights may be transferred. Permission to divert, store, or withdraw water must not be assumed. Of what should the buyer be aware before building on an acreage and installing a septic system? In New Mexico, county health officials monitor septic tanks and private sewage disposal systems. New Mexico allows the use of both aerobic and anaerobic systems. For proper drainage, the ground must be able to absorb the liquid waste. A percolation test is conducted that monitors the time that it takes water poured through a pipe to be absorbed by the soil. A permit may not be issued if there is insufficient absorption. Many counties today are placing very severe restrictions on private sewage systems due to groundwater quality concerns. Brokers involved in a sale should confer with the appropriate authorities. All existing private waste systems must be inspected prior to the transfer of title. The inspection may be no more than 180 days from the date of deed recordation. Any needed repairs must be undertaken within 30 days for a permit to be issued.